Okay, this study session of the Town Board of Estes Park on May 26, 2026 is in session. Is my voice coming out over there? Is it loud? Oh, okay. I don't know about clear, but first topic, we have CIRSA liability and risk as an elected official and general counsel light. I forget your first name though. Okay, got it. Yeah, Sam I am. Yeah. Got Sam and Dan, you know, all these easy lawyer names. Yeah.
Thank you, Mayor, trustees, good to see you. I see you. Make sure I get into the mic there. By way of further introduction, I'm Sam Light, and I'm the Deputy Executive Director and General Counsel for CIRSA, which is an acronym for the Colorado Intergovernmental Risk Sharing Agency, which is quite the mouthful, which is why we call it CIRSA, right? So we're your property insurance provider for property and casualty insurance coverage. So we take, our bread and butter stuff is we provide the coverages for like this building and your vehicles and equipment, and we provide liability coverage, everything from, maybe a slip and fall in front of town hall. Somebody thinks the sidewalk was too icy and thinks it's your fault. We cover those kinds of claims, all the way over to the more esoteric type of risks that municipalities face, like I saw one of the officers here a minute ago, law enforcement liability. We handle those claims, employment practices liability. Perhaps most interesting to all of you is we provide the insurance coverage called public officials liability coverage. That's a good thing. It covers elected and appointed officials acting in the scope of their duties. We're going to talk a little bit more about what that means. So that's kind of the bread and butter of what we do. CIRSA is not a commercial insurance company. We're a public entity self-insurance pool formed under Colorado law. Our only book of business is insuring Colorado cities and towns and affiliated entities, things like housing authorities. So for example, we cover the Estes Park Housing Authority for property casualty and workers' comp. Give you a sense of our size, we've got 295 members. We insure about 90% of the cities and towns in the state of Colorado. Now, being a public entity self-insurance pool, we are a quasi-public entity ourselves. We are an extension of our city and town members. We deal in your public fund contributions to us to help fund the loss fund, right? And pay losses. We get reinsurance at an excess level, but that sort of structure and relationship to our members, I think, changes the dynamic about how we approach risk management, right? Because just as you locally are doing the right things as the governing body of the corporate entity of the town of Estes Park to protect the interest and assets of the town, we kind of aggregate that up, right? And in CIRSA's world, there's only two interests that are important to us, the interest of the member as a member, right? And the interest of the pool as a whole. So we think that informs our risk management offerings to our members. So that's why I'm here. We offer trainings and safety and risk presentations at all levels of the organization, whether it's police, public works, supervisors, HR, but I do trainings for the elected and appointed officials. So this is the opportunity to kind of exercise that risk control muscle a little bit at the governing body level. So you can learn more. I brought some handouts with me in addition to the slides. I don't know if the slides made it into your packet. If they didn't, they'll certainly be available to you, but I've got a couple other handouts so you can learn more about CIRSA on the CIRSA at a glance handout. We'd love to hear from our members, so if you've got any suggestions or concerns or comments, feel free to pass those on to your administrator and get those to us. We're a very flat and approachable organization. We even have one other opportunity for you to approach CIRSA with any questions or comments, and that is we happen to have one of our CIRSA board members right here in the room, and that's Jason Damweber is on our CIRSA board of directors, so thank you to Jason for stepping up for the extra duties as assigned to serve on our board of directors at CIRSA, okay? So I want to make my time as useful to you as possible, so if you have questions while I go through my presentation, yes, sir.
Why do 5% of municipalities not participate?
We're still wondering about that ourselves, but some of them are too big for pooling probably. You know, the Denvers of the world, the Colorado Springs of the world. They tend to wholly self-insure. You know, maybe Denver will probably completely self-insure. Some of the other bigger cities may buy excess, but it's almost all of the small, almost all the small and mid, almost all the mid to large. Right, but not a couple of the really big ones. So that's where the 5% probably lies, 5 to 10%. So Feel free to ask me questions as I go through my material, because I do want to make the time as useful to you all as possible. But I do want to talk about, do you agree with this notion? A good risk management culture for a corporation, including a municipal corporation, starts at the very top, right? In the way you conduct yourselves, and also as an organization, the way you empower and resource the organization to do the right things from a safety and risk management culture. And do you agree with this notion that it's possible for elected and appointed officials sometimes to do things that might get the organization or the individual elected or appointed official in a bit of a pickle? Yes. So we're going to talk about that as well, and some best practices around that. So I've organized a presentation around best practices for liability and risk management at the governing body level to help you think about some issues that should be on your radar around how we conduct ourselves and how we work together to be good stewards of the organization. So got a couple topics listed here that I'm going to touch on. The fiduciary role of public officials. We'll talk about transparency a little bit, just a couple of things on the open meetings law that are on our radar. Talk about organizational structure and liability. A little bit about ethics. We do a separate training on ethics, but particularly for the new member, I want to make sure we got ethics, code of ethics on our radar, and then a little bit about quasi-judicial decision making, because you do, as a board, you have a lot of those applications come in front of you, right? That's a pretty awesome power, right? How big is our planning commission? Yeah. Five? And how big, so what's our population these days in Estes Park? 6,000. So among 6,000 people, at the end of the day, there's 12 citizens that get to make these property rights decisions. Things like, can I rezone my property? Do I get a development approval? Those kinds of things. So that requires that we conduct ourselves differently. That's what I call the quasi-judicial rules of engagement. We'll talk a little bit about that as well, though we do also do separate trainings. And if you're going to CML, still May, I was going to say if you go to CML this month, if you go to CML conference next month, I'll be presenting a session on quasi-judicial making tips and best practices for you all and for appointed officials. So again, feel free to ask me questions with one disclaimer, the two disclaimers, I guess. Though I am an attorney, my presentation is not an attorney-client advice session. And so, but do ask me questions. I do have a good radar, and I'll recognize if it's the live burning question of the day for which you need legal advice from Mr. Kramer. I may still offer a suggestion or two from our risk management perspective, but you want to turn to your town attorney for legal advice. Same thing if your burning question is about something that's in your town administrator's wheelhouse. So, yes, Mayor.
One clarification.
Yeah.
We have 6,000 people who live up here in the valley that are in town limits. We have another 5,000 or 6,000 that live in the unincorporated parts of Larimer. Many of our decisions can have impact on the whole 12,000.
Yeah, so they come as well, right? Yeah, so they feel, even though they're not directly your constituents within the incorporated area, they want to impress upon you a sense of accountability to them as well, right? I bet they do. Yeah.
Someday it'll all be one.
All right, so let's dive right in here. And let me ask, this first one, you've probably seen this slide before if you've attended one of my presentations, but I try to put it in every slide deck because I think it means different things at different times depending on where you're at, collectively as a governing body and individually. So, but let me ask I'll ask all members, do you agree that when you become an elected official, your role and relationship to the community changes pretty dramatically, right? Right? You're no longer just a citizen of Estes Park. You're now a public official, a government official, and I'm here to tell you, from a certain perspective, including a risk perspective, that's a 24/7 job, right? Please have a personal life, please enjoy it, but as you know, right, in the eyes of your constituents, the eyes of your citizens, the eyes of the people you take your counsel from, they're going to perceive you in any setting, right, to be a member of the governing body, right, to be a representative of the town board and of the institution, right? It doesn't really matter what we think of that individually, fair or unfair, right? You got a lot of great summer events here. You may have been out on one this weekend here in town with your family and your friends on your own personal time, but there's a constituent that says, there's a town board member. I'm going to go talk to him about some town business. Was the hat ever off, right? So just remember that, right? Because it does, as it should, your words, your conduct, right? Your actions leave an impression, create perceptions, right? In any setting, right? So keep that in mind, that really from that perspective, it is a 24/7 job. More directly in terms of risk management, Remember, you're no longer outsiders to town government, you're now insiders, right? And on the inside, one of the things that happens, of course, is they don't do this anymore. Well, you can tell me if you did after you took the oath. In the old days, they used to give you a huge book right after you took the oath of office, right? The hundreds of pages of ordinances. They don't do that anymore, right? But it's all there, it's all online, right? When we are on the inside, the rules stick to us. And that's true of the governing body and staff and appointed officials, right? And there's all sorts of statutes and ordinances that governs how we do our work procedurally and substantively. And we don't have the luxury of saying, I don't like that rule, I'm not going to follow it. If it's a rule or policy or procedure or ordinance or resolution, if it's within the prerogative of the governing body to revise, you could do that through the proper legislative process, right? But particularly in quasi-judicial decision-making, you're not, it sounds a little constraining, but you don't have the freedom to say, well, I don't like those standards that apply to this special use permit or this rezoning, I'm not going to follow them, right? We have to, so it's going to be frustrating sometimes, but we have to make sure we understand that we're insiders. In legal terms, make sure we understand we're a fiduciary, right? That term's used in state law, and you can be potentially individually liable for a breach of fiduciary duty. The way I define fiduciary concept is it's the legal obligation to put the interest of the entity that we serve as a fiduciary, i.e. the corporate entity of the town, right, and the public interest above all other interests. That sometimes is going to ask, right, that we make sure we're putting the public interest and the town interest above all other interests, including, do you ever have meetings, Mayor, once in a while where the room's kind of packed and emotions are running high and it's a difficult issue, right? But even when the meeting room's packed, we probably got about 100, right? 100 of our, yeah, maybe even less of our 6,000 constituents, right? So those can be difficult. And you're going to make a decision in that context sometimes that isn't going to make everybody happy all the time, right? But that's a good time from a risk management perspective to fall back on your fiduciary responsibility. Because sometimes people doing those emotional, difficult decisions that try to pull you off track. Council, board, you got to do this, and you got to do it right now. And the next person during public comment says, don't do that, right? And you as a board go, not sure what the best course is, right? One of your best risk management tools, it's not true of a lot of the decisions, but one of the things we do at CIRSA is we defend legal challenges to decisions by the governing body, including claims of like unconstitutionality of an ordinance or something like that, or a challenge to a land use decision. And sometimes, in retrospect, it's perhaps clear that the decision was made on less than great information or was taken in haste. So the way you can help manage that risk for yourselves is to make sure you take the time you need and get the information you need that will help you make good, defensible decisions. Might be frustrating to people who want you to make a decision right then and now, and then and there, or feel like, hey, board, you should have taken care of this months ago. But if you're feeling like you still need to work through your options, you need to have a full deliberation yourselves, take that time, right? And use your staff as resources to help you with that. And of course, as a fiduciary, make sure you're considering issues on their merits alone, right? You ever feel that pull and tug sometimes? Citizen is the gadfly or something, he wants you to do something for a reason, and you're just thinking, that's not the right reason to be thinking about doing this, right? Put those things out of your mind and consider issues on their merits alone. All right, unless there are any questions about those broad themes, let's talk about the open meetings law just a little bit. I'm sure you're in great hands, have great training from your staff about the requirements of the open meetings law. Just a couple of reminders, a couple of things we have on our radar from our risk perspective. Remember, it's a rule of three. It says whenever 3 or more board members want to meet to discuss public business, that's a meeting that has to be open to the public, which simply means the citizens have a right to view that discussion, observe that discussion. Second major part of the open meetings law is if 4 or more people, 4 or more trustees are going to engage in the discussion, or you're going to take any kind of action, that can only occur in a duly noticed, agendized public meeting, where staff takes care of the agenda for you. The openness rule does not apply to purely social gatherings or to chance meetings. So if 3 of you bump into each other at Ed's Cantina, the gadfly does not immediately have, there's 3 or more trustees over there doing business in secret. That's a violation of the open meeting law. That's not true as long as you're keeping it purely social, right? The flip side is you can't allow that opportunity to become an opportunity to talk about town business. So it would be improper if 3 of you bumped into each other and said, hey, good to see you. While you're here, can we talk about the budget amendment that the administrators got on the budget for tomorrow night and work out, right? Meeting before the meeting to work things out would be improper. Meetings after the meetings can be a bad look too. Sometimes, do you televise your meetings? Yeah, sometimes that looks odd to the citizen, right? If you adjourn the meeting and then you're all, gathered around the back of the dais, what's the citizen's inclination? It creates a perception. There may not be an actual violation, but it might create a perception. They go, what are they talking about now? I thought the meeting was over. So be careful of those. Perception equals reality sometimes on this stuff. Okay. A meeting for purposes of the open meetings requirement, the openness requirement includes any kind of gathering, whether it's in person like we're doing tonight, by phone. Nobody does that anymore. We don't even have landlines anymore. Or electronically, which was a phrase added to the statute back in 1996 when they were thinking about what? Email, right? Back when email used to make that funny tone before you connected. But do you agree now there's so many more ways to connect with each other electronically? So does the openness requirement apply to text messaging, for example? Other messaging apps? How about social media potentially, right? Yeah, we've seen claims around all those issues, so just be circumspect and understand that electronic communications in any form can trigger the openness requirement if 3 or more members are having a discussion of the merits or substance of pending matters of public business before the board. Email can be a good tool for some things, but not a lot of things. I've got a handout for you that I take full responsibility for. It's my suggestions for elected and appointed officials on email. Talks a little bit more about how the legal principle attaches, right? Talks about a couple of safe harbors and then has some suggested do's and don'ts. Do you all have your own personal email addresses? I'm sorry, town-issued email addresses? Okay, we'll talk about that in a minute. One hot topic on our radar at CIRSA, we do provide a little bit of coverage. It's a sublimited coverage for dollars for defense for claimed open meetings violations against the governing body only. So sorry, Planning Commission, you're out of luck. This coverage doesn't apply to you. And the reason it doesn't is because we rely upon you as the governing body to make sure your subordinate bodies get the appropriate guidance and training that these obligations apply to them as well. But one of the hot topics we're seeing these days is allegations of serial meetings, right? It really is a rule of 3. 3 or more openness rule applies. It doesn't apply to a one-on-one meeting. So it's perfectly fine as a new trustee, and it's part of the job to sit down and have a coffee with a fellow trustee, get to know each other, understand perspectives and so on, except not on quasi-judicial matters. So 3 or more, openness rule applies. One-on-one doesn't apply. But the serial meeting is a one meeting, right? Where the allegation is that the governing body, through a series of one-on-one meetings, worked everything out in advance, determined what the decision would be, so that by the time they got to the meeting, the action that was taken in the public meeting was a mere rubber stamping, right, of a decision that had already been reached by some outside process that didn't comply with the open meetings law. And I'm sure you've read headlines or seen on the news allegations around that. So be careful of that. Make sure we're self-policing on that. Because violations of the open meetings law, there are legal remedies, but one of the big potential most damaging things could be that faith and trust in how you do your work, right? The remedies include a court order, don't do it again. Okay, well, we know that now, right? But more as concerningly, any action that you may have taken outside of the open meetings law can be reversed by the court, right? That sounds kind of no big deal until we think about what if we took an action outside the open meetings law and the rights of other parties had vested, or people began to rely upon our decision. Now how are we going to unwind that, right, in a way that doesn't cause some injury to someone? So we got to be careful of that. And then, of course, the prevailing party in an open meetings law claims get their attorney's fees. If they succeed in defending those claims on your behalf, we don't automatically get attorney's fees for defense. So it's an uneven fee shifting. And the attorney's fees that are awarded to a successful plaintiff are not covered by your insurance. So it would be a direct impact on your budget. Okay? All right, the other thing I wanted to mention about open meetings was the flip side of that, executive sessions. As you know, you're allowed to have executive sessions. Make sure you follow the script and all that kind of stuff. I would ask that in policing this risk issue from where you sit, you probably use a script, right? Or staff leads you through a motion, but everybody in the room can just keep their ears up and just, did we get it all right? If something didn't sound right to you, don't hesitate to speak up. Hey, did we check all the boxes before we adopt that motion to go into executive session? Because once you go in to the executive session, you really can't get a do-over on those procedural technicalities of the things you have to do in the open before you convene in executive session. Okay, then on policing your own risks and responsibilities to each other when you get into executive session, make sure that you stay on topic, right? You can only discuss the authorized topic that was announced during the public session. So everybody can police that, and it's never inappropriate to ask that technical question. Wait a second, are we getting outside the scope? And conservatively, yeah, if we are, then we need to cut that off and set that discussion aside. Make sure you also police on confidentiality. That can be a little hard sometimes. Do you have executive sessions for matters subject to negotiation? Once in a while, and sometimes in those, you can have those, and the statute says you can have an executive session for a matter subject to negotiation to determine your positions, to develop strategy, and to instruct negotiators, but not for anything else. But sometimes in developing a strategy, you need some background, and staff gives you some background. Maybe it's a land purchase, and you're thinking, all right, well, what are our where's this on our priority list? What's the funding available? And before long in the executive session, you're thinking, isn't some of this information that we're discussing and formulating our strategy already a public matter of public record? So what's public and what's not? Well, presumptively, as a starting point, all the discussions in executive session are confidential. And as fiduciaries, each member is responsible for protecting the confidentiality, right, that belongs to the corporation as determined by its board, right? So a good way to make sure we're on the same page about confidentiality is before we leave the executive session, maybe it's the mayor who says, okay, good discussion, we've given some direction to our administrator. Before we leave the executive session, let's get on the same page here. Of all the confidential information we've discussed in executive session, which information, if any, leaves this room and who's our spokesperson? And now we all have agreement. And now we all understand what our individual fiduciary duty is. And we're bound by that. And that's true whether you voted against going into executive session, and even if you can't stand what was discussed in executive session, no one member should feel that they have the right to leak confidential information. There can be harm to the city's position. There can be, of course, injury to the body as a body, right? I know that can be frustrating sometimes, but if that is an individual's view, what's your remedy? What's your remedy? Is it to go out and share confidential information? No, it's to continue to discuss with your colleagues, can we be more transparent? And decide as a group, right, whether there's information that can be shared publicly. So keep that in mind. Just a reminder, you all know this. Have you been in an executive session yet? Oh, lucky. Fantastic. Remember this, because it's a little opaque, but remember in executive session, except where the attorney asks that the recording be turned off for a privileged attorney-client communication, there's a tape recorder on in the executive session. And those tapes have to be maintained under Colorado law for 90 days. On the 91st day, unless the attorney says we got to hold on to the tape, we're going to destroy that tape. Not the old-fashioned way anymore. I used to, when I had to do this, I used to pull tapes out, cut them up like Richard Nixon. But they're all digital files now, right? They're all digital files. But from where my best practice for you is to remember that there's a tape recording still running. It's very hard for someone to get access to those tapes. But just like in an open session, courtesy, tact, diplomacy, professionalism still matter in executive session. Another sort of thing that's come up is when you all get set, when you have executive sessions, do people leave this room or do you go to another room? Stay here. Yeah, you're getting settled. You know, you're still getting settled, but then the tape recorder was turned on. Let's be careful. Make sure we know the tape recording's on, right? And make sure that we understand that even though it is hard to get a tape recording of an executive session in scorched earth litigation, it is possible, particularly if the claim is a claim that is based on an allegation of motive or animus, where the claimant is trying to get into the minds of the decision makers and prove some retaliatory, discriminatory, other type of animus, and they somehow convince a judge that they're entitled to listen to the executive session tape. You don't want to have your name attached to a zinger that was said in executive session. So just be careful of that dynamic as well. Okay, any questions about open records, that kind of stuff? All right, apart from open meetings law, just remember that you've got that email address, the town email address. I would encourage you to use that to do your business as a public official, right?
So I've got just a couple of questions.
Sure.
Simply because I don't know, I know most states have non-liability provisions for governing bodies like ours.
Yes.
And how extensive is ours compared to, for instance, corporate non-liability ones you would find for a private corporation, first of all?
Well, I don't study the private ones too much, but the public ones are pretty good. And we're going to dive into them here in just one sec.
Oh, okay.
Yeah.
A related question, maybe you'll dive into this too, is that I understand, at least at the federal level, there is a absolute immunity for things said during public meetings by public officials. Is that true here too?
That's a little overbroad.
Okay,
That's a little overbroad.
A little overbroad,
Particularly if
yeah.
you're intruding into administrative matters. There are some stronger protections for legislative and quasi-judicial immunity, but if the action that you're taking can be held to be within the administrative realm,
okay.
then you may not.
So if you're in a legislative, dealing with a legislative matter or a quasi-judicial matter, that's more or less true, but not.
Stronger, but
beyond.
not absolute.
Okay,
Stronger, but not absolute.
okay, thank you.
Yep, great question. Let's dive into them. Yeah. Okay, yeah, organizational structure and liability is how I title it, but it does talk about your protection. So the way I start this section is to, particularly for the new member, is kind of frame it this way, right? That question of, can I get sued and be held individually and personally liable for something I do or don't do as a public official, right? And the answer to that is yes, it's possible. It can happen. But the good news is we have strong protections for you. Well, isn't this great? Under, as you know, as public officials, you have liability, you can face potential liability under both state law or federal law, right? So let's talk about state law first. And what I'm talking about here is whether someone can sue you, for example, under state law for tort and hold you individually and personally liable for money damages, okay? We got a couple of layers of protection, but the primary one is the Colorado Governmental Immunity Act. And the first thing the Colorado Governmental Immunity Act says is that government entities and government officials, elected or appointed or employees, are immune from liability, except in the areas where it's waived. Now, the good news for you as the governing body is most of the waivers of immunity don't relate to the type of work you do. They relate more to the operations of the city from an operational standpoint. So, for example, there's a waiver for injuries that result from a dangerous condition of a building, right? But that's not your role. You're not in charge. It is in terms of budgeting and resourcing the organization, but you're not the maintenance folks. Or there's a waiver for operation of a motor vehicle, the operation of a water and sewer system, those kinds of things. So that's the first layer of protection. But more directly to your individual liability, those protections are in place and say that you're immune from liability, and the town, and by extension its insurance provider, CIRSA, is obligated to defend and indemnify you, right, against any judgments for acts or omissions relating to your work as a public official, right? So long as you're acting within the scope of your employment and not acting willfully and wantonly. So the two key phrases to maintain those protections are scope of employment and willful and wanton. Scope of employment simply means what's my job description, what's my authority, staying within my authority as elected official, right? So that's a very important concept because within every municipal organization, authority and responsibility is delegated, right, to various levels within the organization. But as an easy example, within our own organizational structure in Estes Park, within whose scope of employment is it to determine whether someone gets issued a ticket into municipal court for violation of a penal ordinance? Who would that be? Police. Law enforcement, right? So within whose scope of employment ain't it? Well, not only you, but the administrator and the treasurer and the clerk, right? But there is a role for the governing body within whose scope of employment was it to decide whether or not we have in the first case a penal ordinance, I don't know, for animals at large that led to the ticket being issued. Within whose scope of employment was it to put the legislation in place? You all, right? So you can see that a lot of your work in terms of risk management, right, is to stay at the legislative level, right, where that is your wheelhouse. You're the only part of the organization that kind of does those legislative types of activities, but a lot of your legislation then moves the delegation of authority to people within the administrative staff. So that's scope of employment. You look at your code book, you can see that concept throughout, whether it's the election duties that are performed by the clerk, right, the responsibilities of the town administrator, the police, whatever it may be, right? Certain things are given to the others in the organization and certain things are within your scope of employment. The other important concept is willful and wanton. You are protected from state tort liability as long as you're not acting in a willful and wanton manner, which is just a fancy legal phrase for conduct that's intentionally undertaken designed to injure someone's legal rights and taken with reckless disregard for what their rights are. I just call it bad stuff, right? And we don't get a lot of these claims, but every year we get a couple of claims where some claimant wants to pursue a theory of liability that would create individual personal liability against an elected or appointed official. It's almost always this type of fact situation. It's almost always the elected or appointed official or employee acting individually, right? Misperceiving that they have some governmental authority that they actually don't have, right? Throwing on this purported cloak of governmental authority and doing bad things to people for the wrong reasons. Okay? And it really would be bad stuff. I'll give you, well, I'll ask as a question some examples. If I, believing that I had the right to say anything as a public official, nonetheless made patently false, defamatory, damaging statements against someone, knowing they were untrue, and I published them to the world at large, right, with the intent to do injury, willful and wanton? Criminal acts? Sure. Malicious conduct? What about in the world of ethics? To every reasonable person, it's apparent that you have an actual conflict of interest for which you are required to recuse yourself, but nonetheless, you fail to recuse the conflict of interest because you want to stay in the game to make sure your business competitor never gets approval for the project, and all that blows up and comes out after the fact. Willful and wanton conduct? Perhaps, right? Yeah, so those are two examples of that. We know what bad stuff is. We're going to stay far away from it, but that's where the outer boundaries of those protections are. I don't mean to sound like the Grim Reaper, but it does tie to your insurance coverage, because your insurance coverage, right, follows your role as an elected official, and it says the insurance coverage, the public official's liability coverage, protects you in your capacity as such while performing, right, your duties for the town. But there are exclusions if the civil liability actually flows from a criminal act or willful and wanton conduct. Okay? Now, the way it works in reality, the question is, well, what happens and what does CIRSA do when I've got someone who I think is an overblown plaintiff and they're making allegations against me of willful and wanton conduct, but the allegations aren't true? Or maybe it's a mixed bag, right? And we get that kind of lawsuit, right? Maybe somebody says, oh, I feel like that elected or appointed official wearing some cloak of governmental authority tried to tortiously interfere with my business, right? And they bring a complaint. So the way those are typically handled, we have to analyze coverage. We can only do that when we have an actual complaint in front of us. If we have allegations of willful and wanton conduct, then we'll send the person who's on the receiving end of those allegations what we call a reservation of rights letter, is the way we typically handle those, right? Unless it's essentially unequivocally outside of coverage, our duty to defend is pretty broad, and we'll provide a defense, but we'll do so under a reservation of rights. And we'll tell the person, hey, we're going to defend for now, but if it turns out that your conduct was actually deemed or adjudicated to be willful and wanton or admitted to be willful and wanton, then we don't have any obligation any longer to provide a defense, right, or to pay that judgment. Same thing with the town. Having said that, again, I don't want to sound like the Grim Reaper. In CIRSA's 35, 40 years of doing this, very rare that we have a willful and wanton case that goes all the way to trial. Why would that be? Because when we know it's a terrible case, we got to protect the pool as well, get that case settled if we can, right? But it's all about what's reasonable as well. So make sure we understand those concepts. At the federal level, let's now talk about federal. You got, as I said, you can be potentially liable individually at the federal level too, but we have a good protection for you from federal liability. It's called qualified immunity, right? We hear a lot about it in the police context, but it applies to all of you because you are all governmental actors for purposes of federal, for example, civil rights liability. But it says, right, qualified immunity says that you're protected from individual liability for civil damages insofar as your conduct does not violate clearly established constitutional or statutory rights of which a reasonable person would have known. And I always thought the most interesting part of that phrase from your perspective is, would have known. How do I know, right? As a citizen, part-time, do you get paid to be on the board? Well, still volunteer, essentially. Citizen, part-time, volunteer, legislator. How do I know whether this or that course of conduct or this or that ordinance or decision we're being asked to make, right, is going to run afoul of some constitutional or statutory federal rights? That's where you have resources. And that's where, going back to my earlier risk management suggestion, take the time you need and get the information you need. The way it unfolds in the moment, I've seen this dynamic is Somebody's about to get their land use application turned down, and in a last-ditch effort to save their application, they stand up and say they have their attorney come up and speak. If you deny this application, I'm going to sue each and every one of you for a taking and equal protection claim, and you're violating my constitutional rights. And you're thinking, would have known, should have known, what's the standard, Mr. Kramer, right? But that's where, if it feels like you're on thin ice or it feels dicey, then take the time you need, get the information you need. Maybe it's a memo from your town attorney on what the options are and what. Do you agree that some of the decisions that local government make are kind of on cutting edge issues? And the constitutional law around these issues is still developing, not yet settled, right? Yeah. So, you make sure you get resources and take time to think through those issues. And then you got to ultimately determine your own risk tolerance sometimes at the end of the day, right? But better to have information on that than be surprised by the claim afterwards. Recognize also that certain liability risks, particularly civil rights risks, unemployment practices risks, and tort exposures can be exacerbated by bad facts, right? Even if it feels like there was, well, that's okay, I get it, but that doesn't really have any legal weight, does it? It can, right? That if there are bad facts suggesting like retaliatory, there's a whiff of retaliation to what we did or something like that, that can come back to haunt us in litigation. Okay. A key component of the scope of employment and to keeping yourself in a safe spot, right, from individual personal liability risk is to recognize the legislative administrative distinction, right, that's embodied within your organizational structure. You have a board administrator form of government, and under that structure, you've allocated responsibilities between the board and between your town administrator. You're the legislative and governing body, right? The town administrator is your chief administrative officer who's responsible for the efficient administration and all the day-to-day operations, right? So again, that just sort of frames what's within our scope of employment as a board and what's in the administrator's role, right? And it's not like we're silos, right? We're each doing our own thing. We're mutually supportive in moving the corporation forward. But it's important to recognize, whether it's by statute, ordinance, or some other enactment, if you've assigned delegated responsibility or authority for some decision or administrative function to your administrator, then that's in their scope of employment, not yours, either individually or collectively, right? So a couple of tips around that. Again, just understand the job description. Recognize, do you agree with this notion that elected officials, you take action as a group, right? In all those hundreds of pages of ordinances, as I'm pretty sure there's no ordinance that says the powers of the town board may be exercised by one individual trustee, right? So success individually and collectively depends upon trying to build consensus, collaborate, at least in terms of getting three or more trustees to come along with you, right? But the solution to individual frustrations, right, is not to misperceive the role. Sometimes this misperception can bubble up and says, okay, we've got a 7-member governing body. I must own 1/7 of the power, and darn it, I'm going to go out and use it. You own 1/7 of the ambassador role, right? The great representative, 1/7 of the eyes and ears of the needs and wants of the community. But in terms of taking action, that's just simply not true, right? Does any one member of a governing body, do you have purchasing policies, for example? Yeah, that say like over a certain amount, the administrator's got to bring that procurement to the town board, right? Does any one member have the right to negotiate and approve a contract? No, right? Yeah. Even with, we're going to talk more about employees in a minute, but even with regard to your direct reports that you supervise, does any one member have the right to discipline or supervise the direct reports? Right? It's a we job. So embrace the we. You want to think in terms of we. If you're thinking in terms of I, that can be a red flag, particularly if it bubbles up like, well, you do what you want. I didn't like that outcome. I'm going to do what I want as an elected official, right? Yes, it's absolutely the case. We each bring our own perspectives and policy views to legislating, and sure, fight it out. Bring your own voice, your own perspective to the deliberations of the body, but the body ultimately speaks with one voice, right? Deliberate with many voices, speak with one voice. Here's another red flag. Mayor, do you have opportunity for council reports at meetings or board reports where each member gets to chime in? Usually, sometimes it's near, but most frequently I see it near the end of the meeting. We're about to adjourn and the mayor will say, do any members have anything else to report? Sometimes the dynamic will be, yes, Mayor, I've got something to report. Since our last meeting, I did this. And all the other trustees' eyes open wide and go, you did what? You did what? Right? That may never create a third-party plaintiff in our world at CIRSA, right? But it's a wise governing body that has its eyes open to that dynamic because we want to support each other. And we're busy enough doing the work in this room. If I volunteer to raise my hand, like be a liaison to some outside group in between meetings, then I want to feel like I'm on the same page, right, singing off the same sheet as the governing body so that we don't have surprises. They do, when those surprises come up, unfortunately, once in a while, they do turn into claims where the board wants to discipline or remove the member for some problems around that area. But I think it's a wise body that spots that issue early and as best it can develops common agreed upon expectations and norms of conduct for how we represent the governing body and the institution in between meetings. It's a little more nuanced, requires a little more work, right? Sometimes, right? And also be protective of your own turf. Do you have liaison assignments? Yeah, so you're all, busy enough. Now you got other duties as assigned, right? And I'll volunteer on behalf of the board to be the liaison to this group. You get over there and that group's having their own crisis. And they say something like, well, I need to know what the town of Estes Park, what the town board's position is, because we got to send this letter to the state or the governor. So what is the town board's position? But you're the one individual there on behalf of the town board, and you're thinking, well, I don't know. We haven't even discussed this issue as a board. I think it's your right and prerogative to protect your turf as a town board collectively, right? Say, yeah, we'll get back to you on that later, right? That kind of thing. All right, let's talk about employee relationships. So the adherence to the organizational structure is important in the area of employee relations. How many employees do you supervise as a board? 3, administrator, attorney, and judge. I'm here to tell you from an employment practices liability standpoint, what a great place to be. Because you have delegated responsibility, right, for personnel and employment matters to your administrator and supervisors downstream of the administrator. And I know I'm going to be speaking out of turn here, but your professional full-time staff, right, they love taking all that employment practice liability risk on behalf of the organization. So let them take it. Let them take it, right? It was never in your job description. It was never on the ballot that you were a super HR manager. Now, with regard to your direct reports, you do want to have good, hopefully agreed upon, respectful procedures for giving direction, feedback, evaluating performance, and so on and so forth. But with regard to other employees, that's outside your scope of employment, right? So, but I know there can be pressures. Like, sometimes maybe a citizen comes into town hall and they had some interaction with an employee they didn't like, and now they don't like that employee. What's their inclination? I'm going to call up my elected official and complain about that town employee, right? Trustee Lancaster, you got to get rid of that town employee. And what's our response? I would encourage you that your first response would be, have you talked to our town administrator? I would encourage you to take any concerns regarding staff to our town administrator, because he and the other supervisors within the organization are responsible for our employees, right? Or if it comes from inside, maybe it's hey, psst, can I talk to you about my boss, right? Maybe you have a ready for answer for that. Hey, we love and appreciate our employees, but I as a trustee and we as a board do not get involved in employment matters at that issue. At that level, I encourage you to talk to your supervisor, to HR, whoever else can help you, right? So be careful of that dynamic, because it really is outside your scope of employment. We do have claims where, even with the best of intentions, an individual elected appointed official gets ensnared. Wow. Ensnared in some employment issue, right? And now the employee who's adverse to the organization, they have their own recollection of what that interaction was with that elected appointed official. And now that elected appointed official is right in the mix. And our defense attorneys have to interview them, or worse yet, they got to take their deposition, right? And I've never had an elected appointed official come back to us after we had to take their deposition because they were ensnared in some employment matter ever say to us, that was a lot of fun, let's do it again, right? And remember also, a big dynamic for employment liability is what? Retaliation risk. These systems are in part set up also to help protect the governing body and its members against retaliation risk. So, give your manager, your administrator a little grace when you go to him and say, hey, Travis, I got a complaint from an employee about this, from a citizen about this employee. Give him some grace when he says, I got it. because he does. It's his responsibility, and he's accountable to get it taken care of. But he may only let you know on a need-to-know basis. Part of that is protection against retaliation risk, right? Now, it is true, as you know, once in a while, an employment matter's got a little bit of hair and warts on it, and it's a real mess, and the administrator spots that, it's on his radar, and he may need to let you know, but it's only on a need-to-know basis, so that our communications are coordinated, right? You don't want to misperceive that it becomes part of your scope of employment, right? So, unless there are any questions on that, just keep those things in mind. It's not that things are completely hands-off regarding administrative matters, or even if you heard something about an employment matter, but who's your point of contact to go to with those questions or concerns? Your administrator, right? So make sure you got a
Sam?
process. Yes, sir.
So, having sat on both sides of the table there,
Yeah.
I would always appreciate it if an elected official did hear about something that was going on,
Yeah.
to give me a heads up as the administrator.
Yeah.
Don't just say, oh, that's not my job, and
Yeah.
be quiet about it. And then 6 months later, all of a sudden Travis finds out there was this problem,
Right.
and 3 of us knew about it and never mentioned it to him.
Right.
So I think it's always, if you hear it,
Yeah.
pass the ball down to him and then back off and give it away. But
Yeah.
also, I think it's important not to ignore it.
Yeah. Yeah. Timely. Yeah. He's working on it. Yeah. but
And then we'll hold
timely-
him accountable for not following up.
Yeah, and then enjoy the satisfaction that you've timely unburdened yourself of this administrative or other matter, which is in their wheelhouse to take care of on behalf of the organization. Absolutely. Yep. So whatever it looks like to you, I'm sure you have a nice system, but whatever it is, have a system for bringing forward questions or concerns, that you have or that citizens have. A couple of things to be cautious. Do you ever you interact with citizens a lot? If they come to you and they want to talk to you about some administrative matter, you agree with the notion that there's usually more than one side to the story, right? So be careful of being, sometimes we get well, that's a new member. Do you like process? Yeah. Do we like process? Yeah, sometimes we get a bad rap in local government, but processes are intentional. Administrative processes are intentional to make sure the rules are applied evenly, that we make decisions on an even-handed basis. Sometimes a citizen who's frustrated by an administrative process is coming to you, and they got their version of the problems they're having, and they want you to help them out, right? And be careful. You should have your own risk radar going on and saying, what's really going on here? Am I hearing just one side of the story? Is someone attempting to conscript me into an end run around city processes? You want to be a champion of processes in place. You probably had a hand in adopting them in your legislation, right? And I get it from a citizen's perspective, but it is it might be understandable, but it's a mistaken belief that a citizen might have that individual governing body members, right, are empowered, right, to override or reach a different conclusion than what's required to be reached through your administrative process, right? So we can be supportive and say to the citizen, yeah, I hear you, but you need to talk to our administrator, and then he'll get together with department head, and I'm sure they can address whatever concerns. We're a very approachable organization, but I'm not involved in that decision, right? You can ask your administrator, hey, inform us how that went. Let us know if there are problems that need to be addressed at a legislative level or what have you. Okay. With regard to your direct reports, commit to speak with one voice. And again, by that, it doesn't have to be maybe your administrator or attorney more comforted when it's a 7-0 direction. But whatever it is, whether it's 4-3 or 7-0, commit to speak with one voice to your direct reports, because it's a group, it's one boss with 7 members, not a group of 7 bosses, right? That dynamic can be a little tough. Sometimes the mayor will have an agenda item and we'll say, okay, that was a good discussion. Let's give our administrator some direction. We go down the dais. We got 7 different ideas of what the direction ought to be to the administrator. And we, of course, are going to turn to our administrator and say, Travis, have you got your direction? Right? But who owns that problem? The boss does. You're the boss, right? And so you'll resolve. You just have to commit to bring it back. The dynamic you don't want to have unfold is where you just leave that messy discussion hanging, and then people start dropping by the administrator's office and saying, hey, that was a messy discussion the other night, but here's what I want you to do. Would you be frustrated as one member if another member with a different view were doing the same thing, and we're all lobbying for our individual direction? That's not being fair to the governing body as an institution, and that's simply attempting to conscript staff into resolving issues at the board level that we need to commit to work through, which we will do. We will do. I mean, the mayor in those arts that they practice so well, he looks up and down the dais and goes, we're not going to get there tonight, but we're going to bring it back to the next work session so that we can give our administrative board direction. All right. In a couple minutes we have left, I want to just touch on a couple of things. Remember that you're subject to the Colorado Code of Ethics as local government officials. I did leave you a handout. Recognize that the state code of ethics is many pages, single-spaced, so my one-page handout is a simple summary of some of the most pertinent rules. But on ethics, I think the best risk management tool is just to get a good working familiarity with what the rules are so that you know what an interest is, right? Now, there's some frustrating phrases in there, like it's a conflict of interest, right? If some official action is going to be taken that directly and substantially affects your own personal interest or your own financial interest. Well, what does directly and substantially mean, right? Things like that. So hopefully I'm not speaking out of turn, but I would encourage you that if you are unsure about an ethics issue, reach out early and often to the folks that can help you. Now, your attorney and your administrator cannot serve as your own personal individual ethics advisor, but I think they would love to hear from you earlier than later so they can help you, give you feedback, give you a perspective, right? They work in these issues a lot and can say, hey, this is how the code is intended to work. It's certainly your call at the end of the day, right? You do not have a voting rule, do you? No. Yeah. And each individual then lives with the consequences of that decision, right? But this is unfamiliar terrain sometimes to us as part-time citizen, elected volunteer officials. You know, you got somebody going, you have a conflict of interest. Well, the worst time to deal with it is if you're dealing with it for the first time when it's unfolding at the dais, right? So call your town attorney early and go, hey, I've been struggling with this issue. I see we got this contract on the agenda. I'm not sure if I have a conflict or not. Would this be a prohibited interest? What should I do, right? Make sure we know that for the conflict of interest, we have to disclose our conflict, recuse ourselves from the board discussion. We can't vote on the matter, and we cannot attempt to influence the other decision makers, okay? Do you leave the room when you have a conflict of interest? Yeah, I would encourage that. Yeah, and have somebody else do your speaking for you, right? It can be frustrating. Somebody says, wait a second, I have a constitutional right to speak regarding my own property or interest. Yeah, but you're also a public official subject to the non-influence rule. So I would encourage you to have someone else do your speaking for you, right, in those situations. Of course, there's a rule on confidential information and there's one on gifts. We actually have a state constitutional amendment on gifts that's got a lot going on there. I've just got 2 sentences for purposes of this training to sum it up. Are you subject to the 75? You just follow state code. All right, I think the state constitution can be boiled down to 2 sentences if you'll forgive me for being just sort of succinct about it. The first part of the rule is don't accept any one gift from any one person of more than $75 in any one year if it's in any way related to your status as a public official, okay? Now, the big exception to that is don't accept the gift no matter what its value if it's clear to a reasonable person the gift is being offered to influence your vote on some matter, to reward you for some vote that you've taken, right? Or to get you to depart from the fair and impartial discharge of your duties as a public official, okay? That's a lot of legalese. My even more simple way of saying it is if a gift doesn't feel right, doesn't pass the smell test in the timing and context, then how do we say in a safe spot? We just say no thanks, right? Now, to be fair, there are a lot of exceptions of what's not a gift, right? And rules about other types of things that you can accept. You can plow through those, make sure. But again, I think the most important risk management tool is just to have a good working familiarity. Because do you agree with the idea that sometimes elected officials can be on the receiving end of a allegation of an ethical transgression that's like way off the dartboard? It's like, you have a conflict of interest because you live in this town. What are you talking about, right? It's like, no. You know? Hey, I get it. I hear what you're saying. You're saying I have a conflict because I live in the general vicinity of this land use application. But I've looked at the rules. I've consulted with the town attorney. Here's what I understand the rules say, right? And so then you're prepared to respond to that. Now, the last thing regarding ethics that I'll mention here is, do you agree with this fair, unfair, whatever we think of it personally, that sometimes in matters of ethics, right, perception equals reality and reality equals perception? So I don't have an easy answer to what that means other than to suggest, just think about what that means in your own individual calculus when you're working through an ethics issue, because it can be that you do all the analysis, you check in with staff, is this a conflict? And we clear with great certainty, there's no actual conflict. I have no obligation to recuse myself. I'm going to stay in and I'm going to sit at the dais and act on this matter. But you get to the meeting and it still feels like there's a cloud in the room. Like there's somebody back there in the back row going, what's she doing up here? I thought she had a conflict of interest, right? So remember the power of just making a statement on the record, right? It doesn't cure all difficulties, but I still call it a curative statement. It's kind of a clear the air statement, you know? Maybe before you start the board discussion of that matter, you say, Mayor, you know, before you start on this agenda item, I just want to clear the air about one thing. I want to make a disclosure. You know, I've heard some suggestions or rumors that I have a conflict of interest. I need to recuse myself. I just want to confirm that I don't have any interest within the meaning of our code. I don't have a financial interest or other personal interest that requires my recusal. And I want to remind everyone that I intend to make my decision, right, in this matter and deliberate on this matter solely according to whatever it is, the standards that apply, the best interests of the town, whatever the governing framework is. And that does huge things, right? Because now the people who were the naysayers, well, at least they know now that you thought about the issue affirmatively, right? Okay. That's it on ethics, unless there are questions on that, except to say beyond the code of ethics itself, the legal rules, I would encourage you to commit to personal conduct that strengthens the Board of Trustees as an institution. Truly believe that sometimes for a multi-member public body that will sometimes ask of you to conduct yourself personally in a way that you might otherwise go, I'd rather not do that, but you know what? We all agree we win some or lose some. I'm going to do it for the good of the institution of the board, right? Because part of the fiduciary responsibility might be to, hey, I want to leave the board. When I leave the board, I want it to be stronger than when I came on board, to make the institution stronger. So some of those personal sacrifices might include, for example, making sure that, you know, we set aside a personal interest or agenda when there's lack of support. You know, even if I individually, hey, the only reason I ran this term, the only reason I got elected is I want to make sure we have an ordinance that does this. But if I can't find 3 members to come along, I have to be willing to shelve that interest in view of service of the work plan and priorities of the board as determined by the board. So there's a couple more here. I'll just mention one more of them quickly. Mayor, do you ever have split votes? You ever have 4-3 votes every once in a while? Is it okay if you're on the 3 side of the 4-3 vote to go back to your people and say, I didn't vote for that stinker? Sure it is. Go ahead and tell them that. I'm just an insurance guy. Far be it from me to tell you what you can tell your people, right? But they know how you voted, right? So would the message be a little different in terms of strengthening the board as an institution? You say, hey, I didn't vote for that one, but as you know, this was a tough issue. We had a great deliberation, good discussion as a board. We had a lot of different viewpoints. I fought like heck from my point of view, but the board decided to go a different direction, and I respect the decision that was reached by the board. It does have a liability dynamic. We have had claims where someone on the 3 side of a 4-3 vote could not let it go and attempted after the fact to affirmatively frustrate the effectuation of the decision that was reached. That sound like a good idea? I'll give you an example. By a split vote, a contractor was awarded a contract, and for some reason, one of the decision makers who voted on the no side for that contractor, whatever reason, didn't like that contractor, and then started questioning the billings, started questioning the way they were performing under the contract, started making accusations that the contractor thought were false and damaging to the business reputation, right? And sent a notice of claim. Said this individual, right, with tortious intent is attempting to interfere. Now, you can't interfere with your own contract, so it was kind of an interesting legal issue, right? But nonetheless, it was a problem that one individual created for the whole board because of the unwillingness to just accept the fact that we awarded the contract, and now the administrative staff is responsible for administering the contract, and they'll just do their job. I'm not here to be a super administrator of the contract, right? Or in the land use arena, I had one where somebody attempted to frustrate the approval in a way that we got a notice of tortious interference for that one. So there's a couple more there. I'll just leave a couple more things on personal behavior. I do want to point out that some of the things that we see once in a while that, we need to be attuned as a governing body that we all are a group of co-equals. We each bring our own voices, right? No matter, our jobs are difficult enough when we have difficult issues and difficult folks to deal with, but we want to make sure that as amongst ourselves, right, we commit to civility and mutuality of respect with each other, with the staff that we deal with, that we don't go down the path of having inappropriate personal conduct that becomes destructive or consuming of the governing body, right? Some of the dynamics we've seen are listed here, including one, the first one called the outlier syndrome, or the outlier, syndrome is a chapter in the handbook. But other ones, your meetings, governing body meetings ought not to have surprise moments or gotcha moments, right? Or staff bashing or things like that, right? That no matter how difficult the decision is, we can agree to disagree, right? And then move on to the next item. And I think that's even envisioned kind of in your rules of conduct that you've committed to as a board, right? All right. Last thing to get on your radar, and then I'll wrap it up, is the quasi-judicial rules of engagement. As I mentioned at the outset, primarily within your scope of employment is serving as the legislative body, right? But interestingly, you serve as judges every now and then. You stand in judgment of individual applications for land development, rezoning, subdivision, conditional use, is that what you call them, special use? Yeah. And then how about licensing, liquor licensing? Those kinds of things? All right, so those kinds of applications where you have a specific applicant in front of you, right? Those aren't legislative matters, those are quasi-judicial matters, right? And the touchstones of a quasi-judicial proceeding are we give extra notice, we give more notice to interested parties, and then we as the board hold an evidentiary hearing. Our public hearing is an evidentiary hearing. We allow all the interested parties to come and present their evidence and testimony. And then critically important is that we are the judges. We are bound to make our decision based on the information we learn at the hearing by applying a pre-existing set of legal standards and criteria to the decision, right? In other words, we can't make the decision based on our own personal preferences. We have to set that aside, or our own policy perspectives. We have to set that aside. And the decision has to be made by a fair and impartial decision maker, which is you, right? All sounds a little counterintuitive because you're thinking, wait a second, I was a legislator. I'm a legislator. Can't I lobby and be lobbied? Can't I vote my own conscience on issues, right? Can't I do my own research? For legislative matters, yes. Those are all types of behaviors that are natural and intuitive and perfectly fine for legislative activity. But for quasi-judicial matters where you're the judges, those would be inappropriate, right? And it all stems from the due process clause, right? No person shall be deprived of life, liberty, or property without due process of law. And that means our constitutional requirement is to make sure we honor people's due process rights. There's a handout, by the way, there's a handout on ethics, I think I mentioned. There's a two-page handout on the quasi-judicial decision-making. There's a lot going on there. Again, if you are going to CML and you are willing to listen to me again, I'm doing a session there on the quasi-judicial rules of engagement. There's also a link to one of those presentations at the bottom of this slide. But this slide has a couple of the big ticket items to make sure we understand are part of the rules of conduct that apply to us individually and collectively before, during, and after any type of quasi-judicial proceeding, okay? The only one I want to hit on this page is just from our perspective at CIRSA in terms of defending claims, remember that your deliberations, right, that's like the magical part of the hearing. We're done with the staff report and the applicant presentation and the public comment. The mayor brings it back and we say, okay, board, let's deliberate, talk about how we're going to decide, right? Have a good deliberation. Make sure your deliberations are on point. Make sure that each member, mayor's going to ask each member, do you have any comments, right? Take that opportunity to provide your comments on the evidence as it relates to the existing criteria. Because that record of your deliberations is the only record we will have throughout any legal challenge, right? If somebody challenges a land use decision, we don't have a new trial in district court. We just look back at your record. So in terms of making a good record, that's the time to have the criteria ready, right? And speak in terms of a judge. Like, hey, here's my concern with this application. I find that it doesn't meet this or that criteria because, right? If you're having difficulty, you use what I call Sam's rule of why. Sometimes it can be rocky. We'll close the hearing and the mayor will say, who'd like to start our deliberation on this special use? You call it special use? I'm sorry, Dan. Yeah, we have those occasions. Special, yeah. Who'd like to start? And I say, okay, Mayor, I'll start our discussion of special use. I'm just going to vote no because I don't like it. But just use the rule of why, right? Why don't you like it? I don't like it, right? Because it doesn't meet our standards. Now we're getting somewhere, but are we done? Next rule of why. Why doesn't it meet our standards? I'm going to vote no because I don't like it because it doesn't meet our standards, because under our special use criteria, the architecture must be, the use and the architecture must be compatible with the neighborhood. And I find it doesn't meet those criteria. Are we done? We got to go one more layer. Why? Why doesn't it meet that criteria? Because as indicated in the staff report, it says, I don't know if you have design standards or not, but it says that the proposed building is supposed to meet our design standards, and it doesn't meet these specific design standards, and therefore it's incompatible. Now you've magically made a record just by continuing the why discussion. And staff's going to help you if we get off track in that regard. So unless there are any questions, there's a handout that helps unpackage that a little bit more. I'll just wrap it up with a slide with some concluding thoughts that just kind of encapsulates the things that I've talked about here. Okay. So with that, the last couple of slides are just some more resources for you all about things that we have at CIRSA. We always love to visit. We try to get out and visit our members after the election. So thanks for the opportunity to come visit. We have other events where we like to connect with our members. One of the handouts is we have member appreciation lunches during the summer and fall, and I've given you a handout there. Wherever you may be in the state, if you happen to be somewhere and there's a CIRSA member appreciation lunch, if that's where you want to be that day, then sign up and we'd love to see you. Okay. And then if you're going to the CML conference, we have on Tuesday, the first day of the conference, we have an elected and appointed officials appreciation lunch. We'd love to see you there as well if you can make it. So with that, I'll open it up to any questions that you have. Otherwise, I'm all done with my presentation. So, thank you very much. Thank you for the questions as well.
Very
Good to see you all
thorough,
again.
very useful, very essential. Thank you.
Thank you, Mayor.
Really great. Thanks.
Thanks, staff.
We have the dinner here. We ran a little bit over there and wanting to stay close to target with our couple other items and make sure we have appropriate time. Why don't we just grab the dinner and reconvene here in about 6 minutes? So, okay. Okay, study session back in order. I think Director Carreccia is going to be leading the next two topics. The Development Code neighborhood meeting requirement. There's been a lot of pre-discussion on that. I think a lot of interest in having this discussion. And we'll see what you have for us. And I'm sure you'll hear a lot of ideas from several of the board members.
Thank you, Mayor. I hope so. So good evening. First item, we're going to talk neighborhood meetings. And again, as the Mayor, you said, this is a topic that's been discussed before, and right now town staff will be seeking direction from the board on where we go, if it's status quo, or if there are changes you would like to see in our neighborhood meeting requirements. So just to go through, I know it's in the staff report, but just real quick to go through the process. Neighborhood meeting, it's an informal discussion between a future applicant and those neighbors surrounding the property. It's an established requirement in the development code, so there's certain applications that have to have a neighborhood meeting. It occurs prior to formal submittal. Usually it occurs, the first contact staff usually has with a potential developer or someone wanting to do some kind of change is a pre-application meeting. They'll call the town, I would like to do X, Y, Z. We'll suggest, come in for a pre-app, let's talk, let's see what you're wanting to do. During that pre-app, we'll let them know this is the application requirement, this is how you'll get to potentially the process to get to where you want to go. Prior though, first step, before you even submit that application, you need to have that neighborhood meeting. So it's required before they submit an application. 5 p.m. on a weekdays, we usually ask that they have it in the evening, anytime on a weekend. The applicant is totally responsible for this process. They send out the notice, they pick the place, they do all the notice that's required. Staff will confirm with them, we'll ask for proof, but otherwise they conduct all the logistics for their neighborhood meeting. Staff, it's optional whether we attend or not. If we do attend, we're basically observers. We'll answer process questions, but at that point, we do not want to get involved with negotiations or talking about any sort of project specifics at that time. The applicant is also responsible for, at the conclusion of the neighborhood meeting, they'll prepare a written summary of what occurred at the neighborhood meeting. That summary is required to be submitted with the application. So if you don't have that, you can't submit yet. It's not a complete application. So that summary does need to be included with the application submittal. The proposal before you tonight, again, status quo, we could keep going with our current process. Or in the staff report, we did survey a few other municipalities. They do things a little different. Our process is generally in line with the towns we looked at. It's generally in line with the process that I've used over my career, so we're not an outlier with our neighborhood meeting process. But tonight, staff is interested if you have a different role that staff should play. Do you want to give the director, myself, certain discretion to either waive or require additional meetings? Again, these were things we saw that other towns did with their neighborhood meeting process. And also other things that we potentially didn't think of here tonight that provided in a staff report, open to other recommendations that the trustees may have. Advantages, anything that we can do to increase neighborhood and community involvement, that's a positive. For the disadvantages, I'll talk about the second one just for a little bit. The only thing I'd be concerned with would be introducing any kind of false or misleading expectation in a neighborhood meeting process. I've faced criticisms in the past of neighbors come to a meeting and they're like, I vote no. And I was like, I'll record your opposition. And they're like, no, I vote no. And I'm like, that's not how this process works. We have the due process. We'll need to go through a specific process. And they're like, well, why did I come to this meeting? I was coming here to vote no. So as a staff, we need to make sure that our regulations are clear, that this is an informal meeting for parties to get together, to have a discussion, to discuss the project. It's not a it's not a forum to vote yes or no, and then the project goes away. So that was the only concern I had on certain amendments we might add to this process, that we're clear that what this process is. And with that, Mayor, hopefully that was short, but provided some information. Mostly, I'm hopefully interested in getting your direction on how we can either amend this process or move forward.
Yeah, there's been some beating of this drum quite a bit for a little while, and I've been one of them with one of the drumsticks. The staff thing is a tricky one. We'll probably take some discussion in and around that, so I'm not going to make an initial statement on that. Sooner is always better in terms of the first meeting. I feel pretty strongly, because of how some of those discussions frequently go in the developer and community meetings, where ideas are raised, a developer might say, well, that's something we might consider, or, you know, let me take a look at that. And even though that might still show up in the summary, there isn't a required follow-up. And that's one of the biggest things. The circles aren't closed with what gets opened at that initial community meeting. And so one thought is certainly to have a required closure meeting sometime. Now, granted, they may still be putting the application in, or we may say that that has to occur before the application goes in, that there has to be closure of those issues, either by communication to the community and who attended, or by having a second meeting where that occurs. Obviously, to communicate to people in the community meeting after the meeting, you'd have to have communication points, emails, or presumably emails that they could get an answer from the developer saying, okay, we looked at those 4 things that came up and we're going to do these 2, but there are reasons why we can't do these other 2. And at least closure happens in that regard. There may still be unhappiness, there may still be debate, but whether it's done through perhaps electronic form or whether it's done through a second meeting, I think that's something that we need to discuss. I think it has to be iterative. Otherwise, stuff's just floating out there. Promises might have been made, or semi-promises, or at least to look at it. And I just don't think that serves anybody well. I also do like the written summaries, so I do think that closure should involve a written document for those open issues that were in the original summary. So that's one of the key pieces. As far as the staff stuff, I have to hear some other voices in regard to how the staff might actually work. And I've got a couple people queued up, so let's go ahead and share the discussion. Trustee Ike.
One of the, thanks for coming to talk about this tonight. One of the questions that I have heard raised, and I think that several trustees have embraced the thought that we could do better communicating earlier, is just having an awareness of a project upcoming, for the public to be aware of something that's coming to their neighborhood, whether or not they can influence how that property owner uses their property. And I think that may be perhaps some of the misconception of what their input, the value of their input. So the question I have for you first is, what is the earliest that if someone in my neighborhood was going to do something with their property, what is the earliest time frame for me to know a 4-story apartment building is coming? Is that something, is it going to be published on the website for the town? When will I find out about that as a neighbor?
Mayor, trustees, the earliest that community development would know would be a request for a pre-application meeting. So that's something I believe we put that on our website, future pre-application meetings, in that current development application section. So that would be the earliest. If you were to be interested in what's going on in town, you would check that current applications page. Anything that's been formally submitted to the town, to community development, that's there. All the submittal items, their statement of intent. So you could read 4-story apartment building, property next to my house. You could see those details.
Is that something that someone could subscribe to? Is that and I don't think it is, so I'm just throwing out maybe suggestions, ideas, or a way that we can address a public concern that we are not notifying them properly about these things, including me and my property. I have a vacant lot next to me, so I'm very curious if something's gonna happen. But I do not look at your website every day to see if there's a pre-app meeting coming up. So I think that that's an opportunity to say that we are responsive to your desire to have notifications. And then I think as to your suggestion that people come to meetings thinking no is weighing in on whether the project will go or not, that's probably not going to be effective. But even a written summary or a written statement or a written notice of what that pre-app meeting, the information that meeting contained, would allow the neighbor to be aware and to perhaps get involved in the process. Because I think there are a lot of opportunities to get involved, even if you hate the idea and you want to speak up and rally your neighbors or get the whole community to be aware of something. There are opportunities to do that. But I think that the concern from what I have heard is becoming aware of the upcoming project early enough. So perhaps that subscription idea or being notified of a new addition to the website might be easy to say interested or not interested. It's just an opportunity, I think.
Trustee Brown.
So I've made this proposal previously, and I want to preview it with a couple of things. First of all, obviously the community expressed their concerns with the adoption of ballot issue 300, and some of the concerns, it's very hard to tell the actual nature of the concerns just from adoption of ballot issue, but there's some sense of wanting either more communication or more control over the process, or maybe both, by neighbors. And my sense is that it's happened really principally in residential areas in this community. It hasn't happened that I've seen at all in the community if it's a commercial development. But having said that, I kind of see two particular problems with the current method, and it's based upon comment I think the mayor made that they want to know about things earlier in the process. And I've been around politics a long time, and I understand that you have a lot more impact on the shaping of something if you're involved early rather than at the last minute. And a lot of times by the last minute, there's been so much effort, expense put into it that the parties are unwilling to modify their things. It may take a while for people to gain an understanding of the real nature of something that's going on until later in the process. So what I am proposing that I'd like to get a sense of how the other trustees feel about this, and I have run this by a couple of developers, by the way, and they were, I think, receptive to the idea. And that is that in order to get the community involved earlier in the process, rather than having one community meeting after the pre-application, because for two reasons. Number one is it gives the community a better opportunity to reflect upon what is being proposed before it gets too far in the process. So again, to help with the early stage issue. And beyond that, the developer often expends considerable resources just to get to the pre-application meeting. Now, not always, and sometimes they don't, but often they do. And if they have expended significant resources to get to that meeting, they are reluctant to change it as a result of that. It's very hard to change it once you've expended those resources. So What I am suggesting is that we actually either suggest or require a community meeting before the pre-application, and that at the pre-application, the developer summarizes the comments from the community and their initial responses to those comments that then become available to be discussed at the pre-application meeting. And that following the pre-application meeting and whatever changes occur as a result of the pre-application meeting, then you have a second community meeting in which this proposal has got more meat on its bones at that point. And it gives the developer the opportunity to react early before they've expended significant resources towards the development of, or the planning for the development, to make changes that might mitigate the issues that are raised. And it also gives the community development staff, and hopefully the public, if this were published, the ability to see the response and the back and forth between the developer and the community on the various issues. Now, it may be, there could be some downsides to it for sure. I'm not sure that this is bulletproof. And so it's just a suggestion to analyze because, again, the issues are the community getting a clear understanding of what's going on, and I think it takes more than one meeting to do that. An ability of the community to be involved earlier in the process in order to have a more meaningful voice in shaping what happens. And thirdly, an ability for the developer to get a sense of the community's response to the development early in the process to determine, what modifications can or should be made to meet those objections, or whether those objections simply can't be overcome in the mind of the developer, or need to be responded to in a negative fashion, fine. But the whole thing can be done then in a cost-effective manner for a developer where they're not committed to a project and don't feel not only financially committed, but emotionally committed to a particular course of action based upon a meeting that happens after the pre-application.
I like that concept.
Yeah. I think that sounds interesting to kind of slow down the expenditures up front to get an idea on direction and kind of the resistance or the favor of the project. I was also going to comment on staff that personally, I feel like it would be a good idea for staff to kind of attend these. I don't think that they should mediate or lead it, but I think it would maybe be a good way for a non-biased summary of the meeting on both sides, the public and the developer's side. So it gives a clear understanding of that. Yeah, that's my thought on staff. I don't know how much more you go with that, because the more you do, the more you advertise, the more you do all that on staff, it requires more staff hours, probably more staff, et cetera. So that would be a topic to discuss, how far to carry it compared to, well, it seems like Fort Collins and some of those entities did more on that side of things. So that would be my take on at least staff attending these meetings to give a non-biased approach.
In staff presence, of course, there may be factual things that they can answer in the course, but there may also be questions that they can't without looking things up, and that falls into that same pile of let's get closure on it in the iteration, whether published or a follow-up meeting, would be an opportunity to get closure on those open questions that came to staff in the meetings. Trustee Lanfeast.
So, a couple things here, bear with me. One, I do like the subscription idea. The fact that it's on the website, I mean, it's great, but that's only if you go out and are looking at it. I don't know if you remember that Hitchhiker's Guide to the Galaxy, there's a great scene in there where they show up to the alien planning office and said, well, what do you mean? Earth was going to be destroyed for a space corridor. And they said, well, it's, the plans have been on file for review for the last 100 years here in our office. It's too late and Earth is going to get destroyed. I don't think we're going to destroy Earth, but it is a little frustrating, I think, for somebody who says, well, the plans were there. It doesn't do any good if you don't know they're there or you don't know something coming. So I'm not sure the answer to that. It might be subscription. Maybe it's as simple as maybe in a posting, maybe a weekly posting in local news medias of these are the pre-applications that people could pick up and see. And if they want to look at it, I think there is some responsibility on the other side for people to be aware of what's going on. And I have too often run into this where people have complained about something and there have been notifications, even mailings. Said, well, I thought that was junk mail. I didn't read it. Well, I saw the sign, but I never stopped to read it. At some point, people have to take some responsibility for their community. And we can't go to their house, shake them and say, look, this is happening in your neighborhood. But I think there are some options. Another thing I've always liked on bigger projects is a listening log. And it could be from things that were in the meeting. It could be things that people are saying, but it's online. And you would say, here's the comment, and the developer or staff, if appropriate, can reply. And just single sentence things. So if you're working at a project, then people also gives them an opportunity that may not have been able to go to that meeting to put up a comment about something and say, I couldn't go to the meeting because I was working. I work evenings. I can't go to this meeting, but I'm concerned about the sidewalks in this area and what's going to happen here. And the developer could get on it. You'd have some discussion. I think it has to be somewhat refereed and monitored so it doesn't turn into people trolling it. But a listening log, the other thing a listening log does, it shows people that we are hearing what you said. And it's a listening log. It doesn't mean that just because you say something, we're going to do that. But we heard you. We may disagree with you, or it may not be something that's possible, or it may be violation of code. But I have found listening logs very helpful in the past. And then when something comes up in a hearing, when people say, well, why wasn't this brought up before? You can say, yeah, it was. It was discussed several times. And the thing about a listening log is people write in their own. They see their own words. It's not a summary from a meeting that somebody did. It said, I said this. And you can see their own words, and we did listen to their words. So that's one idea. The other thing about staff waivers, and I'm going to tell the story once, and I'll never tell it again, I promise. But I think it applies. People have heard us before, been talking about growing corn. And so the people who know about it, nodding their heads. So a good friend of mine, a person I work with who was a planner, got out of planning school, got her master's, and did an internship on the Navajo reservation. And part of it was part of their planning process. She developed some codes and things for them. Took it to the Navajo Nation's leadership, and they looked at it and they said, yeah, this is great. There's some good things here, but how does it grow corn? And she looked and said, well, it's land use. It doesn't grow corn. What are you talking about? And the tribal leader said, in our nation, for our entire history, growing corn, whether we were able to grow corn and beans or whatever, and put it aside for the winter, made a difference of whether we survived, whether we starved or whether we moved forward. Everything we did had to be measured by that standard. Is how does this grow corn? It might be nice, it might be fun, it might be interesting, but does it grow corn? And what it really is about how does it add value? One of the things I hate is when we had regulations for the sake of adding regulations, or we had red tape that is just red tape, and You've heard other analogies of we're just kinking the pipes, and if it doesn't go fast enough, then you kink the pipe again, and it just gets worse and worse. So whatever we do, I think you need to look at how does this grow corn? How do we, is it adding value? Which leads to my question about the waivers. Most of the ones that have come up here are the ones that are controversial. They're the big issues, they're the problems. There are a lot of really routine, mundane things that come forward to your office as well. To force those to go through some process, multiple processes, for something that's just expensive, takes time. Frankly, the neighbors don't care because it doesn't really affect them. How does it grow corn? How does it add value? If it doesn't add value, how do you make those calls? And I'd like to hear from you on that. What would be a circumstance where you think, all we're doing is dragging this on, we're costing red tape, it's making the developer and the people around there spending more time than they need to for something, it's not adding value. And the flip side of that, there may be times we want to have more meetings about a particular meeting and have the flexibility to say, this is a big enough deal. One pre-app meeting isn't enough. We might have to have a series of them or more. So can you give an example of one where, because I like the idea of giving you some flexibility of us not wasting you. I would rather have you spending your time on these big issues than having staff and the community spending the time on little ones that frankly nobody cares about, and it's not growing corn. So can you address an example of where it might be one that just you'd waive it or you'd limit the amount of time and effort put into something?
Mayor, trustees, I can offer a very recent example. An application that was denied earlier this year has now come back, a resubmittal. They had to start from neighborhood meeting. That's one that I probably would have said, let's waive that step for you. You did that neighborhood meeting just a few months ago. It was non-controversial. So in that instance, I think that would be that one would justify waiving a neighborhood meeting. And they did conduct a neighborhood meeting, and again, it was not controversial, but they had to check the box.
That's a great example. So, did it grow corn? Did it add any value to make a big meeting?
We've got two more trustees that need to weigh in. We do have one more topic on the study session agenda, so we'll probably not do a full another round, but I think it's actually been pretty robust in terms of the input relating to iterativeness, timing, staff, corn, all the pieces. So Trustee Maris.
All right, I'll be quick. So I think like other municipalities, we can allow the director to possibly be able to waive the requirement for the meeting. I do think that the proactive notifications of the pre-application are a great idea. And I think that, as this goes on, people will get more used to seeing the applications and more used to being involved or not. And I think it'll give them a sense of involvement in their community and a little bit more of a sense of what Bill was talking about in the 300 versus 301. They want to be able to say something, but they don't necessarily want to be able to limit everything. And let's see, I think the meeting before the pre-application is great, but I also don't want to meet before the idea is fully formed. Like there has to be a point at which they say, this is the actual plan and this is what we're going to do. And then, I think the acknowledgement of the potential issues is very important, especially for our community, which cares very deeply about land and development issues. And that closing the loop afterwards, even if it's, something that is not going to be addressed or something that just needs to be acknowledged that, this is going to change. And, unfortunately, we can't do anything about that. I think that's important for the town to be able to process and move on in some ways, and especially in large land use issues that have come through our town recently. And I think that I think it's not a forum for back and forth. I think it's also ideally a forum for people stating what they want, and then a sort of a limited answer response. It doesn't, ideally the developer will take into account what those desires are for the surrounding neighborhood, and neighbors. But I don't necessarily think And I do think that each one needs to be individually considered and answered, but I don't necessarily think the developer should have to, answer to it and change what they're going to do based on what the neighborhood needs, depending on if they're able to make those changes or not. I think that the ideas for what the neighborhood wants in terms of their own community and surroundings is important. And I think that long-term, the developers will want to work with the community on that. Lastly, I think that, well, two things. I think a requirement for online submission before the meeting is necessary, because there are a lot of people that work, and we want to involve those people in our town decisions. So just being able to submit something online that then gets a response during the meeting would be very helpful. And then lastly, I don't think, I'm not a big fan of taking up a lot of staff time with this, but maybe we could, make a form or like a guide for how the meeting could run that the developers could then use.
Thank you, Trustee, or Mayor Pro Tem Hazelton.
Yeah, several of my comments have already been stated, so I'll just highlight those. I think the overarching approach we're all trying to reach here is striking the balance between property rights and responsible development for both the property owner and the neighbor. So I think some of what we've talked about here, we're certainly, I think, really trying to remain community-minded and neighbor-minded. And I think we have to be reasonable. Jamie just mentioned this a little bit. I think Bill mentioned it as well. We have to be reasonable that there are some things that we can't just do the whims of the neighbors legally. We have to, if somebody checks all the boxes, we have to say, yep, you've checked the boxes, so you can move forward. So I would say that while I understand the desire to improve communication and relationships, I think we have to, whatever we structure has to be set under the expectation that not every suggestion from the community will be taken into consideration or into account. So I thought what you had presented in the neighboring communities about that report, and it's been touched on here in one way or another, about the applicant discussing the concerns as part of their summary. And I know they do that now, but to say, here was a concern and here's my response to it. Here's the concern and here's my response to it. And I think designating, here's my response, I'm gonna make that change or I'm not gonna make the change and here's why. I think that's helpful for us to understand where that applicant is coming from and how they might align with community values. Again, that doesn't mean that we would necessarily reject an application if we feel like, oh, I don't really like his attitude. Like, we just had a whole, presentation from CIRSA about you can't really do some things just because you don't like them. But I think it helps us understand if they're aligned with community values and what we're trying to get at with responsible development. So I like that very much. I think Bill's proposal is interesting. You said suggestion or requirement. I think I'd probably go suggestion. I think that also, the suggestion for the pre-application meeting. I don't know if I'd want to make that a requirement, because again, I think then that helps us understand what, sometimes the developer, the applicant, like we keep saying developer, but sometimes it's not necessarily a developer, it's just an applicant. I think if we make it a requirement, sometimes people may be already too far down the line, and so then what kind of pickle are we getting ourselves in there? So I like it as a suggestion, and then this governing body can decide, if they follow that suggestion, does that resonate or not? Did it help the application get in a better position? I'm personally not interested in staff being responsible for these meetings in any way. I think they're welcome to attend. I think it puts staff in a really awkward position to have to provide the summary. Staff have been accused of being biased before, and I think we truly believe they have the best interest of translating the code and the comprehensive plan and all of those things very straightforwardly, but I don't want to give them another position that somebody may say, that's not how I said it, or that's not how they said it. I think that's responsibility of the developer.
I agree.
The applicant. I think they're welcome to attend and discuss process, but I would be very resistant to that. And on a similar level, Frank's conversation made me kind of pause on this, but I had originally written down in my notes for today that I wasn't interested in the director waiving the pre-app for the same kind of consideration, that I wouldn't want to create an opportunity for staff to be, at any level, to be accused of running something through. Now, the example you just gave is a great example. I think that makes perfect sense to say, you just had it a couple months ago, you don't need to have it again. So maybe there's some parameters about how You can waive in there on special cases, but I would probably lean more in the lines of there has to be that meeting unless they hit this very specific potential waiver. And if nobody comes, nobody comes. But we said that it was, it was out there, and that I think provides a level of protection. So that's probably where I would land at this point.
We'll obviously have a subsequent discussion or study session item on this as you begin to incorporate some of these ideas that some of which seem to have fair consensus, but whatever.
Just very briefly.
I am going to let you have the comment.
Okay.
Please expedite. We
I
may
will,
not get
very
to our
briefly.
other topic.
So I support the whole idea of waivers. I think it would be helpful to have standards for that. And in terms of Trustee Eigel's issue about maybe subscriptions, I'm not sure I like that idea because we do give notice by a posted notice when there's going to be a community meeting. And so I think we already do that. And I don't know that we need to send it out to the entire community. We do it now with people within 500 feet. That seems adequate to me.
Thank you. I would say take this, gestate, meditate, and we will have another subsequent session where we continue to develop this theme. We want to do it right. We don't want to slam dunk something based on a couple of opinions, so good stuff. Okay, we had allocated 40 minutes, I think, on the rezoning criteria. We don't even have 40 minutes before the board meeting starts at this point. Travis, do we have sufficient time to discuss this, or should this be moved to a different study session?
Director Crutchia, how long would you estimate your presentation on this one is? It's probably, I'm assuming that this is going to be a pretty robust discussion, and it might be better to delay this.
Town Administrator, I could probably go very quickly through this. I only have a few slides.
Well, perhaps we could hear the presentation and then consider whether to offload discussion to the next study session.
Sounds good.
Yeah. All right.
Okay, Mayor, Trustees, rezoning criteria. I'll skip this one. But just the background, a little context. Again, it's a requirement in the development code. There's 3 criteria that must be met when we have a rezoning, a change of zoning district. Board and the Planning Commission discussed this in August, so that was the last time we had a formal discussion on that. In that discussion, we looked at our standards as well as 10 other municipalities. So we had that matrix. We kind of looked at what others looked at when they rezoned property. No surprise, one of the major discussion points was, what is a change in conditions? What does that mean? How do we apply that? How can we move that into a new set of criteria? So that was something that staff looked at. And again, the direction to us was make something, put some criteria together, bring it back for board discussion. And so that's what we did. 3 criteria still. First one looks at the comp plan, specifically the future land use plan. Is this rezoning consistent with that plan? If it's not, that first criteria then breaks down to, well, if it's not consistent with the future land use plan, was there a change in conditions or circumstances that warrant the rezoning? Or was there an error done in the zoning map that warrants this rezoning? So you have first criteria, or consistency with the comp plan. If not, then it goes to change of conditions or a correction. The second criteria is a robust criteria, and I should go to those. And I know this is hard to read, but I just want to have something on the screen for others. This becomes a more robust criteria, and it specifically looks at, does this rezoning, will this cause adverse conditions in the area? And if so, how are we going to mitigate that? And we have some examples, and these are just examples for Planning Commission and trustee evaluation when you are looking at this criteria. As you can see, it says, but are not limited to. So you're not limited to A through F. There's other things that could come up that you make a finding that if X happens, then I find that it is mitigates the concerns with the area. So 2 becomes more robust versus what it was before. And 3 is much simpler. We're just some wordsmithing here with this one. Again, we thought it was important, though, to keep that if you are rezoning, we need to have the adequate facilities and services. So those were our 3 proposals from what we heard from the trustees. Tie it to the comp plan, the future land use plan. Make sure there's no adverse conditions, and staff, if there are, work to mitigate it. And 3, make sure we can serve the property. So with that, Mayor, I'll open it up.
And they are complex and robust questions. However, we do have a little bit of time on the schedule today, and we can certainly offload subsequent discussion to another study session. I'd suggest that we go to 6:40. If anyone has questions or comments on this now, Trustee Lancaster.
I hadn't even pushed the button yet.
know.
That's what I get for sitting next to the mayor.
No, I just.
Yeah. Couple things, I went through this, I think this looks good actually, and expands it, makes it better. Even the third one, very small change, but the meaning is there, so I appreciate that. My only question was on your, and I know it's may include and it doesn't include, but on A, B, and C, it's all reduction, reduction, reduction. I mean, there might be cases where it's a increase, 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 depending on what the proposal is, or it might be just no change. I guess I would rather see, say, change in the number and type of permitted uses, change or other regulations permitted, just change, not just the one direction on that limits it a little bit.
Trustee Lancaster, sometimes it is, excuse me, that we can only go in one direction. If we've only noticed a zoning change that would allow for a certain density, for example, we might not be able to go above and beyond that density by adding a condition of approval. So in some circumstances, the word reduction is appropriate.
I agree completely, but I think the key part of what you just said, in some circumstances.
Yeah,
Not all circumstances.
Right, I don't think there's a problem with using the word changes as long as we all recognize
Yeah.
that doesn't mean.
I think probably 98% of the time it'll be reduction. I don't want to sit here and the other 2% of the time is, yeah, but we said reduction and now this is not a reduction, and say we're not following our own rules.
Sure.
Other questions or comments tonight? If not, folks have the opportunity to study these in more detail, and we'll take it back up in a subsequent session. And I saw there, Trustee Brown.
He wasn't gonna let you go.
Yeah,
Well, I
you
kept
knew I
waiting
wouldn't.
for the light to come on.
Nice try. I've never liked the terminology change of conditions or change of circumstances, only because it seems like it's very much a matter of what you, the perspective of the person. And, you know, if you interpret them very narrowly, it means one thing. If you interpret it very broadly, it means something else. An example of that would be some of the rezonings we've had in the past where I think staff has interpreted a change of conditions in the fact that we've had an increasing need for workforce housing or an increased shortage of workforce housing, which I'm not saying necessarily is not an appropriate consideration. And I don't have any idea what would be better terminology, to be honest. It just seems like it's a recipe for disagreement and confusion, and to the extent we could tie that down better, I think that would benefit us. I'm not sure we're going to be able to, but and I agree, by the way, with Trustee Lancaster's point about the change, because, for instance, increased buffers or building setbacks, I can see you might have a decreased buffer in some circumstances connected with a decreased, either density or use that goes with it. So I think that flexibility would be important to have in that language.
Mayor Pro Tem.
Just a question, and I apologize if this was in the packet and I missed it. Do you plan to share this also with the Planning Commission and hear their input? Or, I mean, I know we're the ones who decide ultimately, but I'd be curious in their thoughts on this.
Mayor, trustees, we haven't formally scheduled anything. We're trying to work out summer schedules. But we do have a couple items that we would like to bring at the end of the meeting for the Planning Commission, some kind of study session light type items.
Okay.
So, yes.
I'd be interested in their input. Thanks. Otherwise, I think, I agree with Frank. I think it looks really great. I really like how you've cleaned it up. It seems a little more black and white than totally gray.
Trustee Mears.
Yeah, just thinking about Bill's statement in terms of getting this more defined in terms of a change of criteria, I think this in some ways is great to leave a little vague, because in some ways we'll never know all of the criteria that could possibly happen. I think in the strategic planning meeting, it was said like there could be a fire and they may want to change the zoning after the fire to make it more appropriate for the neighborhood or the community. And so I think it's really hard to nail down all the possible criteria or changes that could require a possible rezoning. So I do like the simplicity of that, and I also, like to acknowledge that that's just kind of one part of this three-phase project, which I think is a really good organization of it.
Yeah, I don't like the change of conditions either, but you tried to put fences around it here in the close vicinity, still subject to the interpretation of the board, so there's still substantial amount of gray in there. And I don't know whether there are ways of trying to make that even a little bit more defined, but it's headed in the right direction to try and get away from just that blanket change of conditions. Oh, well, the world has changed. We burned up more ozone, therefore, a change in conditions. So, yeah, that one, a little more honing, I'm still thinking. Number two, the criteria number two, I love the expansiveness of it, because it really, instead of just a blanket general statement, you really are, you've even got odor and glare in there, so it is good for really testing all of those conditions. Go to 3 for a second. And yeah, important change. Very, very small in terms of the words, but very important change. Town Attorney Kramer.
Mayor, the way I would describe what's happening in this draft with the change in conditions language is that it's being brought into a safety valve role rather than being a dominating factor. It only comes into play if there's not alignment with the comprehensive plan.
Right.
So, and in that situation, if it's meant as a safety valve, you might not need it to be as strict.
That helps my understanding, and I feel better about it already. Thank you, Dr. Kramer. So, other comments or questions? Yes, Trustee Mears. Whoop, oh,
You just turned it off.
Turned it off.
Just had one more thought on criteria 2. This might be I'm not sure if it fits here, but it might be a good opportunity to bring in, if we're considering these things when we're thinking about rezoning, to think about like town easements where sidewalks or trails or things might be considered in the future that we could rework in the rezoning. That's all.
All right. I have more meditation time for you, or rumination, whatever.
Well, Mayor, my question would be unless the board would like further study on this item, is the board ready for this to come as an action item?
I think so. We can still, at that point, say, oh, take it back again. But I feel that the conversation has been sufficiently supportive of the changes. A couple suggestions. Okay,
Thank you, Mayor, trustees.
thank you. That concludes the agenda items. Future study session agenda items, Town Administrator.
Mayor, just confirming to re-add the development code neighborhood meeting requirement. We'll come back with that one approved unscheduled. Parking license plate recognition policy, that's been a discussion as of late. Would also like that, add that to the approved unscheduled list. And then Visit Estes Park would like to come talk to you about the dark sky ordinance on August 11th.
Other items for study session items. Yeah, I have a couple things that aren't quite ripe yet, so I'm not going to raise them here. I may comment on them in the board meeting as just initial some things that are being thought about, but nothing to put on the schedule yet. So in that case, this study session is adjourned. We'll be back at 7 p.m. sharp for the board meeting.